Let me make sure. Okay, we are recording. Welcome everyone to the Ad Hoc Commission Fairness Subcommittee Expungement Working Group. I will initiate this meeting by taking the roll. Michelle Anderson, I don't see her quite yet. Ray Buenaventura.
Here.
Sarah Good.
Here, thank you.
Shalon Joseph.
Here, thank you.
Steve Moab.
I'm here.
And Martin Winfield, I don't see quite yet. So we have 4 out of the 6, so we have a quorum. I will first start by asking for public comment. If there's anyone in the public who would like to make a comment, and currently there is no one from the public that is attending this meeting, so I will not ask for, or if any of the staff would like to make a public comment, they can raise their hand also, so I won't limit it to just public. But I don't see anybody raising their hand as of right now. So I will begin with the presentation. So let me set it up and start to, one moment while I get everything set up here. Sharing my screen. All right, can everybody see my screen? Okay. I can't see it, so I hope it's full screen. If it's not, let me know. This is the Expungement Subcommittee Working Group.
Justin,
yeah.
Now it's full screen.
Okay, good. So our goals today are really to focus on the post-conviction expungement and what we want to include in that. I want to initially review what we decided on the discipline on the website, just briefly, because we will have a full ad hoc commission meeting next Tuesday. And the recommendations from this working group will be presented there. And so since it's been a while since we all convened, I want to briefly go over the discipline on the website decisions that were made. And then I want to talk about the administrative expungement that we currently have, and if there is a place for reconsideration, because right now the administrative expungement is limited to one time, and it's only one time whether or not it's an MCLE violation or a late payment violation. But since we're looking at expungement in general, we should also take a look at the administrative expungement. And then the third, which will be a majority of the discussion, I think, is on the post-conviction expungement. And this is where we kind of compare what goes on in the criminal courts and what pieces of that we may want to adopt, because right now there isn't really a process for this, for criminal expungement. There is a way you can petition the Supreme Court, but as we've stated in the past, it's rarely used. And so we would kind of be creating a process for that and determining whether or not there are things discipline related. And then there's also non-discipline related, because some other states, when it's warning letters or private admissions or other things like that, they kind of sunset after a certain amount of time, so they can't be used on the subsequent discipline. So we'll have that discussion at the end. Hi, Steve. I see your hand is raised.
Thank you. Just to be clear, that number 3 is not really post-conviction, it's really post-discipline, right? We're not just talking about criminal conviction and any cases that arise as a result of that. Correct.
I apologize for that.
That's fine. I just wanted to make sure we were all talking about the same thing.
Yes, yes, we are. So as I stated, these are kind of the goals that we want to come to after this meeting. What does expungement mean? Because in the criminal context, expungement means lots of different things, but it doesn't necessarily mean that it's gone forever. And so that definition of expungement, whether or not it is considered for further discipline off the website, off the record or not, is kind of, we want to come to a common understanding of what expungement means and what we're talking about here. And then who should be eligible, what levels of offenses, whether or not we just limit it to, for example, private reprovals or public reprovals or things of that nature. And then once we determine those things, should the process be automatic or based on petition? Obviously, the state of California has done a lot to make things automatic with the AB 1075 Clean Slate Act. And so that's kind of another consideration that we want to talk about. And then also, is there a length of time that someone should wait before they could potentially petition for expungement? So these are like the key questions that I'm hoping that we get answers to as we walk through this discussion. And feel free to raise your hand at any time. I think I can see everybody who's here, but if not, you can always unmute and say it, because I'm doing two things at once. And welcome, Michelle. I see that you've joined the meeting, so welcome. Discipline on the website review. So I just wanted to talk about our previous discussions from the Office of General Counsel memo, Business and Professions Code requires the disciplinary agency shall respond at a reasonable time to inquiry. So this is talking about that we have to make this discipline available to the public. The memo went on to state that the State Bar website is one of several forms that makes the role of attorneys and other members' information available, including records of discipline and things. It said the State Bar is not specifically required by statute to post public discipline online, although it tends to promote transparency and facilitates the public right of access to State Bar discipline. So this is all what was presented to the working group last time. And once we knew this and took this into consideration, the working group looked at other agencies and other states and what they did specifically within the Department of Consumer Affairs. We compared what the nursing board and what the medical board did with their discipline and how long it stayed on the website. And a lot of consideration was made for things coming off of the website. Now, this is just purely the attorney profile page. We're not talking about expungement or the records. It's just availability on the website. Someone could still call the State Bar or write a letter or come into the office and have access to that discipline. That's how the other states have done it. And I think the nursing board had a very clear disclaimer saying that on the website, these things sunset after a certain amount of time. So it was very clear to the public that if there may be additional information that they need to inquire within. And this is trying to balance public protection and also the attorney's right to have served their past and moved on from that. So the decisions that were made at the time, these were the categories that were discussed. And next to the categories, so private reproval, the decision was when conditions were met or 1 year, it would be removed from the website. For public reproval, the decision was 3 years from the website. And then probation with stayed suspension, it was 3 years or the conclusion of probation. And then for probation with an actual suspension, the discussion, and I'm not saying that this was unanimous, there were some voices that were concerned that these were maybe not as long as they should be, but the consensus was probation with actual suspension, 5 years from reinstatement. And then disbarment, the discussion came that it was very important to keep it on the website permanently. And so that there was no change to the disbarment on what would be on the website. So these were the discussions. When we present to the full ad hoc commission, we'll bring back some of those slides that were helpful in facilitating the discussion. And I just wanted to remind the committee of what they've done and if they have any questions on any of this. And I don't see anybody's hand raised. So then I will move on to the administrative expungement piece of the agenda. So in 2 instances, an attorney will automatically qualify for expungement, and their California Rule of Court 9.8 and California Rule of Court 9.31. And 9.8 has to do with the failure to pay licensing fees. So if you're suspended because you failed to pay your licensing fees, you can have a one-time expungement. And then for 9.31, it's a failure to take all of your or meet your MCLE requirements. And so if the current conditions are met, you are eligible for that. And the conditions are basically, the suspension was short, so 90 days or fewer. The suspension was ended at least 7 years prior to the date of the expungement is sought. The licensee hasn't had any other expungement for either MCLE or the failure to pay fees. And they have no other record of suspension or involuntary and active enrollment for discipline or otherwise. And the bar still continues to maintain these things, even if they are expunged from the record, for the Commission on Judicial Nominees Evaluation. So there is a requirement for the bar to maintain the records. They're not completely wiped free, but they are removed from the attorney profile. The difference between these two is the one for failure to pay fees is from the Supreme Court. So the Supreme Court is ultimately enacts that. And so the Board of Trustees adopts the resolution, but then it goes to the Supreme Court to act on those. The MCLE failure to meet your MCLE requirement, this Board of Trustees does. It has been delegated. And so the Board of Trustees enacts the inactive status and then can put them back into active status. So it doesn't go to the California Supreme Court. The question here is, you saw the requirements, and I'm going to stop sharing for a second if I can figure out how to do this so we can see everybody on screen. So you saw the requirements for the administrative expungement. You basically get one shot at it, whether or not it's the MCLE or the failure to pay fees. In other states, some of these things are, once you become in compliance again with whether it be your fees or your MCLE, it's just removed from your attorney profile page. It's not kept on there forever. And so since we're talking about expungement and talking about things, this is an area, since there's only one chance to do it, and it's only MCLE or the failure to pay fees, is there any thought that there would be changes the working group would like to see in regards to administrative expungement? And so that's the kind of question that I'm throwing out to the working group now. And there doesn't have to be. I mean, the consensus can be, it's fine as it is. We don't want to expand it whatsoever. But I just wanted to throw it out there because we're going to look at kind of heftier issues, actual discipline considerations, and these are more administrative issues. But if I don't hear anything, and no one has raised their hand, so I'm going to take that to be administrative is just fine, and we're going to leave it as it is. And I will do so. Okay, let me start sharing my screen again. Okay. So post-conviction expungement. And this is where I think that this working group, a lot of you have a lot of experience on the criminal side, and so you're very familiar with this. So this is just kind of a brief high-level overview of what the criminal expungement is and what aspects of that we may want to bring over when we create, if we create an expungement process for the state bar. So Penal Code 1203.4, conviction expungement. The eligibility for the conviction expungement is misdemeanors and some felonies, and there are certain requirements that have to be met to be eligible for this type of expungement. You have to be completed or discharged probation with complying with all terms, not serving sentence for any other offense, not gone to state prison, not charged with any other offense, met all your restitution and had all your fines paid. So these are some of the eligibility requirements. It allows the defendant to withdraw a plea of guilty or not guilty if they were convicted, and set aside the verdict. And this is useful when applying for like housing or employment and educational scholarships. There are all sorts of exemptions to when you do have to still mention the conviction on your record. If you're applying for, I think I list them on the next slide, peace officer applications, if you're applying to public office, for firearms, licensing agencies, the Lottery Commission is always in there somewhere. So these are all of the exemptions from the expungement. So yes, you don't have, for most, landlord, when they're doing background checks or private companies doing background checks, it won't come up anymore. But for these specific things, there are exemptions for the expungement process. I did want to talk a little bit about the Clean Slate Act. And this act authorizes automatic relief in the form of set aside and sealing. So this is the big difference, sealing of the convictions and arrests. It was originally only from 2021 forward, but then they passed AB 145 to go back and extend it to 1973, which was actually in the original bill, but it got pulled out. And so they went back that far. And it will prohibit the courts from disclosing this information. So this is really sealing it, or granted in the future that they will be eligible. And so this hasn't actually been implemented yet because there has been delays, and it's about the costs associated with this and the DOJ implementation, because they set aside a significant amount of money to get this implemented. But this is really making these things automatic. And that's kind of the trend on this. And that's why I bring this up to the working group is that these are automatic. The DOJ is responsible monthly for going through the records and seeing who's eligible for this and fixing or changing the records and notifying the courts to do this. And so I just wanted to point this out, that that's kind of the trend in the criminal context in California only. There are 49 other states doing different things, but this is the trend here. I also wanted to talk about the other states and what they do towards expungement. When we got the responses from the national, the bar councils from other states, most of the expungement talk was on closed complaints with no discipline. Those are what most people said yes to when they meant expungement. There were a couple other states that had a little bit, it wasn't even, I wouldn't even call it expungement, but it had kind of the same purpose. Delaware has a diversion or probation kind of contingent that if they don't engage in professional misconduct during the period, then it's kind of, it's waived. So that's kind of like a diversion program. If you complete this program, then it's gone. They also said you can petition for a single private admission to be removed after 10 years. So if you had what I would equate to a private reproval, after 10 years of a clean record, you could petition to have that removed. And it's only one time, and it's only that one private admission. Massachusetts, it's not an expungement, but it talks about the admissions are vacated after 8 years, but the records are still kept. And from what I could tell, the vacated means it can't be used in subsequent discipline. It's still on the record, but it can't be used. New Mexico, informal admissions, so I'm thinking these are like private reprovals or warning letters, may not be used after 10 years. So if there is no further discipline after 10 years, they can't be used. And in Pennsylvania, the informal admission, which I'm thinking is like a warning letter, or it's something similar to that, after 4 years, and then private reprimand after 6 years are not deemed relevant if no other discipline has occurred. So if you get a subsequent discipline complaint and 4 years for an informal admission has passed, they can't use that towards the new discipline. And so these are not technical expungements because they're not expunging the record. It's just after certain lengths of time, stuff happens to your record where it can and can't be used. But this is because there's not a lot of expungements in other states. This is what we have to go on. So are there any questions? I just want to stop. Are any questions on other states or kind of the criminal context? And I don't see anybody's hand raised, so I will move on. Business and Professions Code 6092.5 states this state bar expunge records of the state bar as directed by the California Supreme Court. This is what we've talked about in the past, that we could only find 2 cases of. Trying to find out why people don't use it more. I tried to research that with our Office of General Counsel and things, and trying to find out why someone doesn't do something wasn't an easy task for me to do. And so I wasn't very successful on why people don't petition the Supreme Court more. But it is not widely used right now. I just want to remind that there are non-disciplinary outcomes that we can look at, because some of these can be used in future discipline. So even though they're non-discipline, if you do an agreement of lieu of discipline and there's further discipline on the subject, the agreement of lieu and discipline can be used with that new discipline. So I wanted to review the non-disciplinary outcomes, which are resource letter, directional letter, warning letters with or without conditions, agreements in lieu of discipline, and referrals to the lawyer assistance program. So these are all non-disciplinary outcomes, but they can have an impact on future discipline. And then this slide you've seen before, because it's the disciplinary outcomes, are the private reproval, public reproval, probation with stayed suspension, with actual suspension, probation, and disbarment. And in terms of the universe of complaints that we're looking at, I had Ron pull the data for me to give me a quick table to look at, so you can just see what we're talking about in terms of numbers of discipline. So if we're looking at disbarments in 2021, there's 84, and these numbers, don't quote me, they may change a little bit as numbers get pulled and stuff, but these are roughly what the numbers are. And so when we're talking about expungement, obviously it's not just a one-year thing. We're talking about expungement over many, many years. So these numbers, but I wanted to kind of get the size of the number of attorneys that could potentially be impacted and give a rough size of that. So as you can see, there's not a significant amount of public reprovals and private reprovals every year. We're talking in the 30s, 20s, and 30s. The stayed suspensions, it looks like it's around 30. This year it's a little more. The actual suspensions, 100 plus, and then the disbarments 100 plus, something like that. I don't know where we're going to go with each level of discipline when we look at this, but I just wanted, in terms of the people impacted, these are kind of roughly the people that are going to be impacted. So brings us back to the discussion on expungement. I am happy to go back and present different slides along the way if they're going to be useful. But that's kind of my short presentation on expungement in the criminal context. So my first question is, what are we thinking that expungement would mean in the state bar? If we're looking to expunge things, are we thinking that they would be stricken from the record? Is that what we're looking at for expungement, or sealed? What is the working group's thoughts on expungement?
I guess
I have a comment.
Oh, go ahead, Ray.
So at least for me, when I think of expungements, let me see if I can turn my camera on. Sorry. I am the reason why they are necessary and effective is it's only if the conviction, for lack of a better term, is not discoverable. So if this is truly going to work, it has to be to where the person who is at issue is able to say they were not convicted nor is it a way for someone to discover it and to find out. And so that's I think the two main goals are to be able to say I wasn't convicted, and for no one to be able to find it. And that's what expungements are for. So that's my comment.
Thanks, Ray.
I understand why Ray's saying that, and what he's saying makes sense. That certainly in the criminal context, that is absolutely the sort of the definition or the gravamen of the expungement. I don't know that makes sense in our context. Number one, I mean, I guess if somebody is applying for a job or something like that, then maybe they would say that they have discipline or they don't have discipline. It's not like they would necessarily be saying to a client, I haven't been disciplined or something like that if a client comes in and is looking to hire them. And so I think in some ways that's different. I also think that the statutory requirement that the state bar provide the information upon request to the public who inquires is also different here. And while I have interpreted that to include a inquiry to the website of the profile page as an inquiry into their history, I understand the disclaimer, and we talked before about how we could say very clearly this is only through the last 5 years or 10 years or 1 year or whatever it is. You can call for more information, and I get that. At the same time, if what we're saying is that it would not be discoverable, I think that we would need to do some. We would need to seek some statutory changes. Number one, not to say that we couldn't, but I think we would need to. And I would also just point out that I think that a lot of the criticism of the state bar has been that the state bar is too easy on attorneys, is not does not discipline sufficiently, etc. Now that may or may not be true, but I think that's the perception, and I'm concerned about anything of us going to the legislature saying, hey, we're going to hide this information from the public. I'm not sure how our stakeholders will react to that.
Hi, Sarah.
Hi, I just wanted to add that I really share and join in Ray's comments here. I understand that some stakeholders may not like it, but I think our argument is we have the Farkas report and other things that we're dealing with that put us into this exceptional circumstance, and that we need to address and remedy some of those inequities that were in the system. I mean, I could see an exception maybe if somebody was applying to be a judge, so that if Jenny was looking at it, they could see the whole history. But other than that, I think it shouldn't exist. Nobody should have to disclose it, and it shouldn't be on the website. And I know that when we talked about what should or shouldn't be on the website, we distinguished that from this discussion. But I would simply adopt our suggestions for what is eliminated from the website into what may or can be expunged. So some of those timetables, I would just adopt kind of whole scale into this discussion. Thanks.
Thanks, Sarah. I will add that this ad hoc commission has its own charge, and it's going to be making recommendations to the full board of trustees that I think is going to have to consider the recommendations. We're coming from the ad hoc commission after the Farkas report and the Robertson recommendations, and they can judge that and weigh that and decide what they want to do with that, because the board of trustees is much more intimately involved with the legislature and the stakeholders and things of that nature. So I think I've been told that the ad hoc commission can make its recommendations on its own, and that this is just part of the process that would get it there eventually to the legislature. And obviously the Supreme Court's going to have a big voice in what ultimately, goes forward and gets adopted, because a lot of these things impact the Supreme Court. And Steve is correct that there will be legislative change that need to be, which is a long process in and of itself. So, but I think this commission can make its kind of decision on its own, and knowing that there is some input from stakeholders, not saying that you totally ignore it, but they can make their own decisions and pass it on to the Board of Trustees for what they want to do. So hi, Michelle, you can.
Hi, I just had a comment because we're looking at what goes on the website as to what the public can also obtain. Now, if information is expunged, does that mean that if they call the office and ask for additional information, that whatever was expunged is also withheld?
Well, I think that's the decision that the working group needs to make. In my mind, that's what we're talking. The difference is we're talking about, yes, if someone calls in, if it's expunged, what I've heard from Sarah and Ray is that if they call in, it's as if it didn't happen. It is non-disclosable. And so it would be expunged even if you called in. I think Sarah said the caveat for the Ginny Commission, which I think is reasonable. But in terms of public or anything, it would be expunged from their discipline record, is what I'm hearing from Sarah and Ray. Correct me if I'm wrong.
And okay, so if it's expunged from their disciplinary record and the public wouldn't have access to it, however, a subsequent complaint comes in, would the record still exist in some form or matter that could be considered by trial counsel?
I think that's a discussion. I don't want to speak for Sarah and Ray. I will let them. But that's a good question. That's kind of defining expungement. Is what does it mean? Does it mean non-disclosure for everybody? Or does it mean, that there still retains OCTC's ability to use it as furtherance in subsequent discipline? I don't know, Ray or Sarah. So,
at least in the criminal context, if a case is expunged, the prosecutors, they obviously have access to records regardless of whether or not a case was expunged, and they will often say, and they can legally say that it doesn't matter if it was expunged, we can consider that as a prior conviction in deciding what next steps to move forward. So it still can be considered. It's just that the benefit of an expungement for the defendant or the attorney is that it stops with them. They're able to say when something's at issue, they can just say I was not convicted, or pretty much that. So it still can be used, at least in the criminal context, in considering the factors on what the next step would be in the criminal case. But as far as using it, it's up to the prosecutors. That's all I'll say about that.
Well, then my response would be that that would accomplish one of the goals if we were trying to eliminate disparities and people being able to look at the disparate treatment and not be able to select certain attorneys based upon their past disciplinary record, and they have somehow fixed that process, or we've provided services for them to bring themselves up to par, whether it's additional courses that they need to take, or they've done whatever the probationary or whatever their disciplinary action required them to do, once that's completed and they've met the time period for the expungement, then it's off the record and the public should be satisfied. But that would also allow trial counsel, if a subsequent action came, they would be able to look at that and consider it. And if they find it relevant, it's relevant. And if it's not, it's not. So I think that's a strong argument for eliminating these records.
Okay, thank you. Sarah.
I was just going to say, I think that the OCTC and the State Bar Court need to be able to consider prior actions in determining the appropriate response to maybe future disciplinary proceedings that might be before them. And if we were to say that they couldn't, it kind of eviscerates the concept of progressive discipline, if you will, right? If you can't consider it, then there's no progressive discipline. I still think that can come with some education or information or a statement with respect to how to treat certain disciplinary outcomes that were targeted by the Farkas report, so that the State Bar Court and OCTC can take that into consideration in terms of their recommendation for discipline, and then ultimately the discipline that's imposed. So that's it for me. I think it just has to be able to be considered within that context, but the conviction, if you will, is still kind of expunged to employment, education, all of those other things.
Okay. So I think I've got the OCTC and State Bar Court could consider it, but that it would otherwise be expunged. So it wouldn't be on the website anymore. It wouldn't be publicly available anymore. What about, and we talked about Jenny, but if an attorney is applying for licensure in another state, they want to go work in New York, would they have to disclose it if it's been expunged? It's just a hypothetical, but I'm trying to find the definition.
So if I make a comment on that, I thought that very often when you're applying for licensure in another state, or even things like a judicial appointment, that the questionnaire would say, have you ever been the subject of a disciplinary action, regardless of whether or not discipline was actually imposed? That sort of covers, I'm thinking, maybe the need to make exceptions and to say that if you're applying for another licensure in another state. So maybe we don't need to worry about making a whole bunch of exceptions when things like that, things like those applications, I think they already have built in a question that covers whether or not the person has been disciplined, but they just want to know.
Sorry, you got there before me. Go ahead.
Go ahead, Steve.
Oh, okay. Thank you. So I understand Ray's point. If it does say whether or not you've been disciplined, then I guess that's one thing, although we don't know what all the other jurisdictions say. But I guess my concern would be if we are telling people that they don't need to reveal this, that they were in fact disciplined because it has been expunged, when they're faced with saying, were they the subject whether or not they were disciplined, are they going to interpret that as, I don't need to say that and I don't need to reveal it, and therefore they may find themselves in trouble at some point down the road with that other jurisdiction to which they're applying. Is the one point on that. And then sort of going back to this OCTC use of the discipline, which I agree with and I think is reasonable. I guess my concern as a former, I guess, and current, consumer protection attorney, is what's the public going to think when they find out that we've now disciplined somebody for the second time for some conduct that, and they couldn't find that information when they considered hiring the person in the first place. I think that they would be somewhat outraged, and I think maybe appropriately so. And I think that's potentially problematic. I understand the rationale to give that information to Jenny and to allow them to consider that, although in some ways that's not any different. And it seems like if we are not going to give that information to the public, then maybe we shouldn't give it to Jenny, or maybe both. Maybe we should give it to both. I guess I just continue to be concerned about this.
I think there, Steve, it's a question of the time period between the act and the discipline and the expungement, and making sure that those time periods are reasonable to address your concern about public transparency. If it's too short, then maybe your concern is more legitimate. If it's some legitimate passage of time, then it kind of goes the other way. So maybe that's how it's addressed. And on Jenny, since the committee is administered by the state bar and they get a lot of things automatically, I just think they should automatically get the history as part of their backdrop to interviewing somebody to be on the bench. In terms of other bars, I guess, in my mind, it's up to them to ask the question appropriately. It would be kind of horrible to have a huge list of exceptions. I think becoming a member of the bench is easy to make an exception for that. But I might not go so far as to create other exceptions there.
Okay. So I think we're closer to a Sean.
So, a comparison could be made to law enforcement. If law enforcement is terminated or disciplined and then goes to another agency to apply, they do not have to reveal that. So I don't know if there's a way to look at other entities where we can do this comparison, but I do think there are other agencies that don't have the requirement of disclosing in this, and especially if a time period has passed where it doesn't seem that it should have to be disclosed. If that makes sense.
Mm-hmm. Okay. So in rough terms, it means that it is non-disclosable. It is expunged, and which means non-disclosable to the public. But the carve-outs are OCTC can use it for subsequent discipline depending on the time period that we may define. And it is still one carve-out for the Ginny Commission. Those are the rough parameters that I'm hearing the definition of our expungement would be. Is that what are we all on the same page? I see a couple nods.
Yeah, that's acceptable to me. Thank you.
Okay. So now that we have kind of the rough definition, I'd like to go into what should be eligible. And when I talked about the non-disciplinary outcomes, I think the purpose in other states is that if a certain amount of time has passed, say like 10 years, then a informal admission goes off and can't be considered going forward. In our definition, we're not precluding OCTC from using what was expunged as going forward. So is there anything in the non-disciplinary outcomes, specifically, I guess I would talk about warning letters or agreements of lieu and discipline, that we would want to consider for expungement? And because they're non-disciplined now, they're only, they're just informational to the attorney and then only used in subsequent discipline. So that's the question I posed to the working group. Sarah.
I don't think we need to deal with that personally.
Okay.
So, but, by definitionally, I don't think we need to deal with it.
I agree with Sarah.
Okay. All right. Then we will move on to the discipline. So we have the different levels of discipline, and I'll share this slide real quick just so we can all see. Hopefully we can see the levels of discipline. So this is where I would like to kind of have a discussion on what levels of discipline would be eligible for expungement. I'm assuming not all, but who knows? And with the private reproval, I want to remind the working group that there are two types of private reprovals. There's the initial private reproval that is done before notice of disciplinary charges happens, and then there's the private reproval that's after the notice of disciplinary charges. And the private reproval before the notice of disciplinary charges is not disclosed to the public. It's something that is just done internally and is not on the attorney profile page. If the ultimate resolution is private reproval, but it happens after the notice of disciplinary charges, that is on the attorney profile page. And so it does stay on there even though it's private. So I just want to make that small distinction between private reprovals when we're considering what would be eligible for expungement. Sarah.
First, can somebody explain to me the differences, why there are two different kinds of private reprovals and why the outcome would be different if charges were filed? I'd be interested in hearing about that from OCTC and what their perspective is on it. And then secondly, I think it might be useful to put up the slide with what we determined for the website time periods, just to have that side by side. For my part, I would adopt that, here. And I don't know about other people, but they may want to. And it may be kind of helpful to look at that at the same time.
Okay.
So perhaps I can answer the question, at least procedurally, is about the difference between the private and the public-private. When we file a case with State Bar Court, when we file a notice of disciplinary charges with State Bar Court, that is a public document and it is a public case. So if we resolve the case for a private reproval prior to filing with State Bar Court, then it is just private by virtue of the fact that it's a private reproval. If we file it, if we agree to a private reproval after it has been filed with State Bar Court, there is something about it that is public. The notice of disciplinary charges has been filed and it is public. And so the stipulation that it is for a private reproval is also technically public because the case is public, but we don't publicize it. We don't, do anything along those lines, but it has been filed with State Bar Court. So that case is public. So that's why it's called a public-private. As far as the timeframes on the discipline on the website, I think that in some ways, if we adopt those timeframes, which you may recall, I thought were too short when we adopt them for the website, and I think would definitely be too short if we adopt them for overall expungement. But if we did bring them over, then there would be no purpose for the disclaimer, right? Because if we had the disclaimer on the website saying this sunsets after a certain period of time, so please call us for more information, there would be no information to give because it would be expunged. And so I will reiterate my concern about the time frame.
Thanks, Steve. So hopefully you can see the slide. Says I'm sharing. Okay, thank you, Sarah. So these are the levels of discipline. And again, Sarah has made an initial proposal, and Steve has cautioned against that initial proposal. And there are, in the criminal expungement, if you do, a actual time in state prison, you're not eligible for the expungement. And that's kind of like equating to actual suspension. If you have a several-year actual suspension, you might think there might be a parallel for there. But does anybody else on the working group have thoughts on what levels of discipline should be eligible for expungement?
I have a question, if I may.
Of course, Ray.
I want to ask about disbarment, and what is the rules of when an attorney gets disbarred? Is there a specific time period that disbarment will stay, and what is the procedure for trying to get back their license? How long will that take? And do you know if disbarment, as by way of an expungement, has that been allowed in other jurisdictions?
I can answer the first part of that, Ray, and that is that disbarment, they can petition for reinstatement after 5 years. I can't tell you necessarily how long that takes. There is a period of discovery. They file a petition. They have to file it. It's certainly not automatic. There is a period of discovery, and then there is the state bar court hears a case for reinstatement, and then we'll issue an opinion. And so it's then acted on from there. I can't answer the last part, and I don't know if Justin can either, about what other jurisdictions do as far as expunging it. When we had talked before about it remaining permanently on the website, we had discussed the danger of the unauthorized practice of law, and ensuring that the public was aware that that person was not qualified to practice law any longer, which was sort of the rationale for leaving it on the website, and I would argue is the rationale for not allowing expungement of that now.
And Ray, most of the other states that responded in terms of expungement all said that all discipline is permanently on the website. It's on there. And some of those states that had that did take off lower level of discipline, but anything with actual suspension, a couple of states, I think Kentucky and another one, that anything with actual suspension or disbarment stayed on the website permanently. But that's a small sample size, but I'm not aware of anybody taking off disbarments. So, so we're thinking that we would allow expungements for all of the levels of discipline up on the screen right now. I heard from Sarah.
Yes.
Sarah, yeah.
I was going to say, I support, not permitting expungement of disbarment, since there is a separate process for somebody to get reinstated. That's well trod and people take advantage of it. So I'm fine with just considering the first 4 bullets for some sort of expungement process, and then letting disbarment, be handled in the ordinary course as it is now.
I think I support Sarah's position as well. I mean, even in the criminal context, you can't expunge a murder conviction, and a disbarment is the highest level of poor conduct, bad conduct on the part of an attorney. So, and I'm glad to hear there is a process for a disbarred attorney, and rightfully so. It should take some time and some rehabilitation. So I support Sarah's comment.
I'm in agreement, Michelle Anderson.
Okay. And Shalon? Not to put you on the spot.
Justin, I think she dropped off the call.
Oh, okay. I was sharing, so I couldn't see. So, okay. So I've stopped sharing. So that the expungement, when we're talking about what can be eligible, the next kind of conversation is this petitioned or is it automatic, that we would desire this process to be? Is it something that they could petition the Supreme Court after that certain amount of time has gone, or is it something that we would try and set up some sort of automatic process that this just takes place, that I guess the state bar would have to configure? Michelle?
I think they should have to petition. I'm a little bit conflicted on it, but I believe that it should be on the person to petition for the expungement.
Okay.
I think that they should be well informed of their rights and, all of that stuff, but they should have to petition.
Okay. Sarah?
I think some of them can be automatic, and some of them should be by petition. And I don't have your bullets in front of me, but maybe the lesser discipline can be automatic, and the other ones can be via petition. I think, part of the rationale for AB 1076 to make it automatic is that some people, may not pursue expungement, due to lack of resources or something else. And I think if somebody is already a licensed member of the bar, we can presume some education on their part and some ability to kind of pursue a petition process. So that's kind of where I come out. So I think on the 1 year, 3 year, I'd probably make that automatic, although I could be persuaded otherwise, and then have a petition for the actual suspension process. And I think it should also be clear that nobody will have had any prior disciplinary activities that would have come up in the interim during that time period, right? That they will otherwise have a clean kind of record, if you will. That's what I would kind of propose.
Okay. Ray?
Yeah, so bringing it back to the criminal context, what happens in criminal court is you actually have to petition, but after you petition, it takes 1 or 2 directions. The first one, it's automatically granted because it's statutorily mandated that the expungement be granted. So that's one direction it goes. And then the other direction it goes is discretionary. So then there have to be factors that have to be met in terms of whether or not deciding to grant the petition. So I think what Sarah's proposing actually makes sense, because if one route is automatic, pretty much, it's just by filing the petition, then why don't we just eliminate the filing of the petition, since it's automatic anyway, and go one set of a group of people to automatically do it, because it's such, you know, it's not, there really aren't any issues. But then the other group has to be sort of discretionary, where they do have to petition and they have to go through the motion. That's it. Thank you.
Okay. Michelle.
I think the reason why you need to file the petition is for there to be a check mark, or not a check mark, but to make sure that all of the conditions of probation or whatever, the reproval or suspension, have been met. And that is one of the reasons for the requirement of a person applying for the petition, so that somebody can double check to make sure that those petitions, that the conditions have been met. And if they've been met, then generally, yes, it goes through. But when people, for instance, try to apply for an expungement earlier than necessary, or before they have completed their terms, there's the ability of the prosecution or whatever to determine that, hey, no, they haven't finished their terms of conditions, or wait a minute, they haven't paid the restitution, they haven't paid the fines. I think that's part of the reason for the petition process. So I don't think it should be an automatic when you're talking about practicing law. It's a privilege, it's not a right. And so I think that when you're in the disciplinary system, I realize and I understand and I recognize that there's disparities, but it still is a privilege and not a right. And I think that if you're talking about the disciplinary system and you're waiting for things to be expunged, I think you should have the petition.
Okay.
Can I just ask a clarifying question? Michelle, is that also applicable, for example, to private reproval, sort of the lesser of the, is that kind of your view? I just want to make sure I understand your position.
I think a private reproval, I don't feel as strongly about, but I do think that that you need to petition. I do think, when we're talking reprovals, that's at the lowest level, but yeah.
So I guess whether petition or not, what I got from Ray's comment is there can be a difference and a distinction between the lower level, where it's more administrative, even if you have to petition, but you check all the boxes and it's kind of automatically granted, versus the higher level of discipline where there is some discretion in the petition, and whether or not it's granted or not. Did I hear that right? Is that what the working group is thinking? Or I'm just trying to understand the process and whether or not it's purely check the boxes, or there is some discretion for the higher levels of discipline. Sarah.
That's what I understood Ray was suggesting, which was what I had in mind when I used the term petition. That sort of implies discretion. So, I mean, that's kind of what I think we're suggesting.
Okay.
I do think it is important, putting the issue of whether there's a petition or not aside for just a moment. I do think it's important, as Michelle said, to make sure that the conditions have been met, that fees and costs have been paid, that restitution has been paid, things like that. And so whether a petition is necessary in order to ensure that that has happened, and it isn't just automatic in the sense that after a certain period of time it drops off, that's important. I did understand Ray's comment, like Sarah, to be that there were two tracks.
Okay. Okay. So I think I have that there's kind of two differing opinions as to the lower level, whether or not it be automatic or not. And then the higher level, there seems to be consensus that it's petition in terms of what we're looking at now. And since I had those times up on the website, and I can put that slide up again, but the last kind of question is, how long should the time period elapse before this expungement takes place? And I know that there has been comments, and I'll share this slide one more time, that Sarah, you said you were kind of comfortable having it be the same as it is on the website, which would eliminate some things. But I'm curious, is the rest of the working group, is this the amount of time that they would like to see passed before someone is eligible for expungement to petition?
I think we should be consistent, and so I think if we've agreed to this time period, it should be the same.
I mentioned this earlier, but just to be clear, I disagree respectfully that these time frames are not sufficient to give adequate warning to the public, and I would frankly seek higher periods for the website and then higher periods than that for expungement.
So what would you propose, Steve, and where do you stand on automatic versus, discretionary petitions?
Well, I mean, assuming that we could check to ensure that the time frame, the conditions were met on all of them. I understand, and there's some. I don't think it's unreasonable to say that the private and public could be, the non-discretionary type of thing, assuming those conditions are met. I do think any type of probation, state suspension, actual suspension should be fall in the discretionary category. And frankly, I would probably put those at 10 years. I think that the private and public, my inclination would be that those would also be at 10 years, although they would be automatic and the others would be discretionary. I am mindful that, there is no other bar that I'm aware of that does this. I'm looking at my notes to make sure that I'm not wrong, but Florida and Texas, for example, they remove it after 10 years from the website, but they still have it available, like when people call in and stuff like that. So it may be that there are other bars or regulatory agencies that don't have the information online at all, things like, but they don't have it online and then remove it and expunge and whatever. So we're in new ground here, and I think that these periods of time are not sufficient.
Thank you, Steve. Michelle, do you have comments?
I think I'm kind of in agreement with Steve. The reprovals are not so concerning to me, but I think the suspensions, I think the time period for expungement information is a little bit short.
Okay. Well, you won't be the first working group to have two different recommendations to bring to the full ad hoc commission, but that's why we have diversity in opinion. And so I appreciate that. I think that is, that has kind of answered the questions that I had with this expungement. I think, are we thinking, I mean, this can be settled later on as to who the petition is to, whether it be state bar court, the Supreme Court. I don't know if the working group has ideas on that. To me, I think it makes sense, since the discipline was adjudicated by the Supreme Court, that the petition would be to the Supreme Court, but I don't know. Or do you think it would be state bar court, Steve?
I think that at least the first round should be state bar court. Yes, my guess is that the Supreme Court has many other things that occupy their time, and they would
busy.
have interest in taking the first look at these things. I would expect that the state bar court would hear it at an initial level and potentially make a recommendation to the Supreme Court.
Okay. Does that make sense to the working group? Okay.
Yes.
Yes.
Okay. I still sharing. I can stop sharing. All right. I don't have anything further. I don't know if anybody else has any questions or concerns or anything they wanted to be brought up.
I just wanted to say Happy New Year.
Happy New Year. Well, I really appreciate the working group getting together today. As you've seen, next Tuesday, we have a full ad hoc commission, and part of that is bringing the rest of the commission up to speed. And so we will be, the ENEC working group and this working group are farther along than the other ones. And so we will be discussing potential recommendations that would be part of a final report that will eventually get reported or distributed to the Board of Trustees. We're hoping to have a preliminary report in March. And so those two working groups will have actual kind of formed recommendations, not set in stone, but discussions on those. And we'll bring forward the opposing sides, or not opposing sides, but differing sides of the recommendations. The other, if you notice on the agenda, the other working groups are more of discussions because they haven't gotten as far along, and we're using that time to kind of have the discussion because we have a finite date. And so I wanted to use some of that time to have working group discussions there. So the closed complaints working group and the discipline costs working group will kind of have discussions where the full ad hoc commission will meeting. And so I'm trying to use everybody's time judiciously, and when we're all together to try and get these things done. So that's the plan for next week. And we have an ENEC meeting tomorrow morning too, working group meeting. So we'll probably have another full ad hoc commission in late February or early March to formally adopt some of these recommendations. So I appreciate everyone joining today and their participation, and we will see you either tomorrow or next week.
Thank you. And thank you, Steve, for your valuable input. Really appreciate it. Thanks.
Thank you all. I appreciate all of your time.
Thank you. Bye.
Hi, everyone.